We're joined on Capitol Hill by Senator Jack Reed of Rhode Island. Joining us this morning, hours ahead of what could be the final day, Senator Reed, of the impeachment trial. What do you think is ahead today in the Senate?
Well, I hope that we could successfully get witnesses. I mean, this is a very basic issue as you're contemplating a serious decision for the American public. You have to ask yourself, would there be readily available information that will help you make a better decision? And it's obvious, yes. If we could listen to Ambassador Bolton, he has firsthand knowledge of the charges, the allegations. We should do that. It does not appear that we'll be successful in getting that testimony, but we should do that. And I'm still holding out some limited hope that perhaps we'll find some Republican senator that indeed believes that we should have all the facts on the table. And more importantly, the American public, the people, should hear directly from Ambassador Bolton. So I hope that's the case.
Well, play this out a little bit. If indeed the articles come up and the vote fails for witnesses and the Senate moves to a final vote on the articles of impeachment and those fail, what's next for the Senate in terms of any of the issues that the House has brought to it, the articles of impeachment? Is there any further action?
Well, I think in terms of formal impeachment, obviously not. That is the sole prerogative of the House. In terms of issues that could come up, in terms of our responsibilities for oversight of the executive, that's a constitutional Article 1 authority. We have to do that. And one of the fears is that the president will be emboldened. The president will say, listen, I stonewalled this thing completely, never let a witness go by, never responded to an inquiry, never gave a document. And guess what? He could say, well, I don't want to cooperate with this committee in the Senate, particularly if they're looking at something that might infringe on what I did politically rather than in terms of policy matter. So I think there'll be thoughts, obviously, about what our legitimate responsibilities are. And again, it turns on our obligation to the public and our obligation to the Constitution.
In your conversation with senators on the opposite side, we heard from Senator Collins, who would vote for allowing witnesses, and then Senator Alexander of Tennessee saying he won't vote for witnesses. Where do you think the line is in terms of what Republican senators are grappling with over witnesses, those who had been on the fence?
Well, I think those on the fence recognize, as I suggested, that, you know, that we've got a constitutional obligation. Forget party, and I know it's difficult to do that, and, you know, if the shoe is on the other foot, that is a very good rule, I think, that was expounded by the President's Council. I think looking at those facts, though, if this applied to a Democrat, if the accusation was that a Democratic president, used U.S. resources to get a personal political favor, I think first of all, we'd want all the information to confirm or deny that. And second, it does raise, I think, to the issue of an impeachable offense. It's an abuse of public trust. And I think my colleagues have been debating the same issue, going back and forth. It's a difficult issue, but I think the weight, in my view, the overwhelming weight is at least get all the information on the table. And again, it's not just for us. It's so that the American people, all the people that call into your show, are not reacting to arguments that are one-sided by the President's Council or the House managers. They're looking at the real information and they're making a judgment for themselves. That's the most vital way we can have a strong democracy.
One more thing, when it comes to that final vote on the two articles of impeachment, do you anticipate any of your Democratic colleagues voting for acquittal?
There might be. Again, you know, when you consider these votes, there is obviously a sense of, you know, the party identification, but it diminishes. This is one of those moments where you take an oath to be impartial. It is a constitutional issue that we have. It's not a routine matter of legislative oversight of something else. And so you have to respect the fact that all my colleagues on both sides of the aisle might make decisions that you would not agree with. What you hope they do is they do it carefully, they do it based on the facts, they do it based on a reasonable interpretation of the law, and that they are able to explain to not just themselves, more importantly to the American people, precisely why they made that decision. In fact, when colleagues come up to me and ask, you know, what's the biggest decisive factor at the end of the day, it's being able to thoroughly, thoughtfully, and sincerely explain to your constituents what you did. And I think if you do that, then the people will accept whatever you do.
One more for you. Early in the trial, the Chief Justice had mentioned the Senate being the world's greatest deliberative body. I know it's early and things are wrapping up, but what do you think the first draft of history will say about this, how the Senate comported itself during this Senate impeachment trial?
I think the first draft will make the obvious point. This was not a trial. Every impeachment, we've had 15 of them in the history of the United States Senate, several involving presidents, all had witnesses, and not just House witnesses, but many were called for the first time by the Senate. That's the essence of a trial. I think they'll say it was rushed, that there was not sufficient time to evaluate and talk to all the witnesses. So the first draft, I think, will be this was a rush procedure that did not do what historically the Senate had always done. Stepped back, took its responsibility seriously, got all the facts they could on the table, and then made a judgment based on the Constitution.
Do you think the Chief Justice could be in a position to break a tie today? Do you think that might come up?
If there's a 50-50 vote, there is precedent in the trial of Andrew Johnson in 1868 for the Chief Justice to make procedural votes, and a witness issue, calling a witness, would be a procedural vote. That's a possibility. I must confess I doubt very seriously if the Chief Justice would do that, but I think he could do, historically, he could do it.
Senator Jack Reed of Rhode Island, thanks for joining us this morning.
Thank you, Bill.